Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today, we're talking about drunk driving. Cases that should have gone to the Supreme Court of Canada, but didn't. Kirby Thomas was involved in a motor vehicle accident with Daryl Quinlan at around 12:30 in the afternoon. 3.5 hours later, at around 4:00 p.m., Mr. Thomas was stopped and ultimately investigated for impaired driving. He was charged with impaired driving, pled guilty to impaired driving, and was sentenced for impaired driving. Mr. Quinlan, as a result of the accident, sued Mr. Thomas for negligence and asked that he pay for certain losses that he'd suffered as a result of his injuries in the earlier collision. In Saskatchewan, where the accident took place, there was legislation barring these types of lawsuits from being brought on the basis of the fact that the insurer deals with all of those things. They have a universal insurance system in Saskatchewan. However, there's a provision in the insurance legislation in Saskatchewan that indicates that people who are convicted of impaired driving are not subject to these provisions and that such lawsuits can be brought against convicted impaired drivers. This was Mr. Quinlan's position. Because Mr. Thomas had been convicted later on that day, he must have been impaired at the time of the collision. And the court initially allowed the lawsuit to proceed, allowing him to say that Mr. Thomas had been impaired at the time the accident was happening, notwithstanding the fact that the conviction for impaired driving stemmed from a traffic stop that happened 3.5 hours later, and there was no continuous observation of Mr. Thomas in the meantime to ensure that he had not consumed any intervening alcohol after the accident and before getting in his car a second time, or become impaired over that course of time. The Supreme Court of Canada was ultimately asked to hear the case and denied the opportunity to do so. This case would have been a really important decision for the Supreme Court of Canada to make because of new provisions in Canadian law that require that people not drink alcohol after they've ceased to operate their motor vehicles. There's a provision now in impaired driving law in Canada that says that if you consume alcohol and get to over the legal limit within 2 hours after ceasing to operate a motor vehicle, that you're guilty of committing an offense. And there are provisions in Canadian law that if the samples are taken more than 2 hours after the time you cease to operate the motor vehicle, allow a judge to just automatically add back to get to what your blood alcohol level was at the time that you ceased to operate the motor vehicle, essentially allowing a person to be convicted potentially of impaired driving for a significant gap of time between when the actual driving takes place and when the police investigation begins. This was an opportunity for the Supreme Court of Canada to get out ahead of these new laws and to provide some clarification about what happens in situations of lost continuity and what elements of proof are necessary. Even though this was the civil context, they could have provided very good guidance on the way that the intervening alcohol consumption and intervening levels of impairment might play into the determination about whether or not to convict an individual. And the Supreme Court of Canada should have seen what is ultimately going to be coming before them and taken the opportunity to decide it now, to shut it down, and to get ahead of these cases that are going to clog up courts in Canada for years and years and years until they make their way to the Supreme Court of Canada as a huge jumble of messy decisions with various outcomes from various provinces. This was an opportunity that was missed to clarify the law before the court was asked to clarify the law that is currently in place. And unfortunately, now it means that a big mess of cases is ultimately going to wind its way up at the Supreme Court of Canada, where they're going to be asked to determine pretty much the same thing that they were asked to determine in this case, and it's unfortunate they did not take that opportunity. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases that should have gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law Corporation. Please like, subscribe, and share with your friends.